Hello, I'm Natasha Karamichou, and in this podcast, we will continue elaborate on donations. What is a donation? According to Article 496 of the Civil Code, the provision of property to a person constitutes a donation if it is made by agreement of the parties for nothing in return. A donation is a contract which creates an obligation only for the donor, who by entering into the contract of donation assumes the obligation to provide the recipient with an asset, thereby increasing the recipient's property and reducing his or her property respectively. The essential elements of the donation contract are, on the one hand, the provision or promise to provide an asset, and on the other hand, the agreement of the parties without any return, which is subject to notarial form. This asset may be movable or immovable, and in cases where it is immovable, a notarial deed must be drawn up. The legislation on donations is regulated by the Civil Code. A donation to be valid, it must be accepted by the recipient. The donor, in the case of a donation, is liable for fraud and gross negligence. What is not a donation? Donation must be distinguished from acts of kindness which take place in the context of social activity, because acts of kindness there is no intention of parties to be legally bound. Acts of kindness include, for example, inviting someone to a dinner or providing hospitality in one's home. How can we donate? Regardless of its type, object, and value, the contract of donation must be made in a notarial deed, in accordance with the Civil Code, otherwise, the donation is absolutely invalid. The donor is in principle not liable for actual and legal defects of the object of the donation unless he or she promised that there are no such defects, or if he or she knew of their existence and fraudulently concealed them. A combination of articles of the Civil Code clearly shows that, for the transfer of any real estate ownership by donation, among other things, an agreement between the donor and the recipient in a notarial deed and its registration are required. The acquisition of ownership of the transferred real estate takes effect from its registration to the National Land Registry. Therefore, without any registration or with an invalid registration due to essential defects, ownership is not transferred to the recipient. A lawyer, acting on behalf of the donor, should check the correctness and legality of the title deeds, the existence of any mortgages or seizures, the content and terms of the contract to be drawn up, and collect the necessary documents required for this purpose, which more or less are the same with those of the parental benefit. After the submission of the necessary documents, the notary public will draft the text of the contract, which includes the description and acquisition history of the property, the special conditions, and finally the acceptance from the recipient. The public notary will also post the donation tax return on the fiscal authority's website. The process is completed with the signing of the contract by the parties and the registration of the deed at the relevant land registry. What about the donation tax? It is the recipient who is liable to pay the amount of tax due, which is determined according to the value of the asset transferred and the relationship between the donor and the recipient. The same fiscal scales apply on the donation as well as the parental benefit. What is the difference between a donation and a parental benefit? A parental benefit is the transfer of assets such as property or money from parents to their children with nothing in return. Unlike a donation, which can be made to any person, a parental benefit concerns only first degree of kinship, parents to children, and is aimed at creating or maintaining economic independence or starting and continuing a business. Can we revoke a donation? According to Article 505 of Civil Code, the donor has the right to revoke the donation if the recipient has committed serious misconduct and has been ungrateful to the donor, his or her spouse or close relatives, and in particular if he or she has failed in his or her obligation to provide for the donor. Ungratefulness, within the meaning of the above provision, justifying the withdrawal of the donation, is understood as the recipient's lack of gratitude towards the donor manifested by antisocial behavior or conduct towards the donor or his or her spouse or close relatives, contrary to the rules or prevailing ethics of morality and decency. Furthermore, under Article 512 of the Civil Code, donations made out of a particular moral duty or on grounds of decency cannot be revoked. This is, for example, a donation made out of consideration of decency or in accordance with social customs or public opinion or out of social obligation. To summarize, there are laws and legislation to duly cover any case and type of donation or parental benefit. It is useful to get an expert legal opinion and proceed with any property settlement in due time because laws are constantly changing and every case is different.